has come on record.
Kindly permission, Lord. Serial number 20, please, Lord. There is some inconvenience. I informed to the other side also, please, Lord. Serial number 20, Lord. Accommodation. Please, Lord.
Lords, I'm opposing adjournment in serial number 20, my lords. We have not been informed, my lords.
20, we are,
Chinnappa, sir, I have
20 adjournment, we are also opposing.
Please.
Sorry.
Serial number 111, madam. Serial number 111, madam. Again, senior councilman is not available today. It's 2 weeks I can come.
May I make a request for?
Serial number 111, madam.
111. What do you, after vacation? 24th of June as requested by learned advocate for the appellant.
May I make a request?
14. After vacation as requested by learned advocate for the petitioner, stand over to 25th June.
Serial number 13, your worship. Serial number 30.
39.
30.
1. Delay is there, notice, returnable on 26th of June. In delay application.
May I make it one matter for
Yes,
admission?
madam.
This matter for it.
Fresh matter, moving memo, your lordship. There is one connected matter which was listed yesterday. It could not read, so your lordship gave a date for tomorrow. It may be listed along with this.
How it is connected?
It's arising between same parties. It's a commercial appeal.
Same parties, many matter may be there.
It's regarding the application which was rejected in the before the honorable commercial.
कम कर दो उनका फोन बंद कर कम करो बाद में करो बहुत है Why don't you change?
My lord, serial number 54.
My lord, this is mentioning a commercial.
So how it is connected? There may be many matters between the same parties. Is connected in what way?
It is arising between the same parties with
Same
regards
parties,
to.
you know.
At least it may be sent to the scrutiny branch. My lord will send our.
You tell us how it is connected. Deriving out same judgment.
Please, my lord.
Then say that.
One matter.
My lord,
One matter for preliminary. One matter for admission, writ appeal, fresh matter. 1988 is the acquisition. Final notification 89. Matter went to up to Supreme Court has been concluded. One of the landowner questioned the matter before this court. Then 48, one of the act has been ordered to delete this portion of the property that has been questioned before this court.
After vacation.
No, may I make
My lords,
there is a
serial number 54, my lords. 1 week time may be given, my lords. Office has raised an objection on my rejoinder. 1 week's time.
54.
54.
It is not under office objection. Already on vacation. 23rd of June.
Surprised.
My lords, it's a writ appeal. My lords, arising out of a decision wherein I am a society, my lords. My registration was earlier approved. It has subsequently been, that order has been revisited by the first respondent, my lords, without any jurisdiction. My lords, the urgency is this. If that order is acted upon, my lords, the writ appeal will be rendered infructuous without an urgent basis. My lords, I'm just requesting for any date next week or my lords in the third week, as per your lordship's convenience. The only urgency is, my lords, any sort of action, precipitated action, my lords, that we're anticipating will render the writ appeal infructuous.
How?
My lords, it's essentially because my registration was earlier approved. That was subsequently revisited and then has been cancelled. That order was upheld by the learned single judge without noticing that the earlier order was passed without jurisdiction. my lords, what we will establish, my lords, through case law is that this honorable court has previously held that there is no jurisdiction to revisit under the provisions of the Karnataka Society's registration. Any early date, my lords.
21st.
21st.
Lord one, commercial appeal arising out of rejection of the application for interim injunction not to create third party interest and also not to alter the nature of the property can be dismissed. The urgency is that no, they are proceeding with the construction and also they are creating third party interest.
25th April.
So, petition PIL seeking a mandamus to remove the encroachments made in the Raja Kalwa. Encroachments made in the Raja Kalwa. To remove the encroachments made in the Raja Kalwa.
4th of June.
Serial number 35, my lord. Seeking adjournment, my lord.
Lord, serial number. Lordship, may I make a submission? Your Lordship, serial number 29 and 30. Similar matters were posted yesterday. Your Lordship, were pleased to adjourn the matters to 26th, Your Lordship.
June.
Yes, please, Your Lordship.
26 June as requested, 29 and 30.
Please, much obliged.
Your Lordship's fresh contempt petition. Fresh contempt petition, it has not been listed from 2020 for your Lordship. The last occasion I had moved a memo, it was supposed to be listed on 7th, your Lordship, but the same was not listed.
24th. 24th.
Lord, 37, Lords. And for respond number 2 and 3, Lords. I need, Lord, some time, Lord. The government and last date, Lord, has filed an affidavit.
24th June as requested. 36.
Start date in my lord, I need first week of June, my lord. In that matter, first week of June.
First week of June. 5th of June.
Great.
Your Lordship, serial number 22, Your Lordship. I appear for petitioner.
23.
22, Your Lordship. I seek for a adjournment, Your Lordship.
23. No.
I have informed the government advocate also after vacations, Your Lordship. Bless you.
When it is called out, we'll see. Yes.
Memo for posting, Your Honor. Compliance ಇದೆ, Your Honor. Compliance comply ಮಾಡ್ಲಿಕ್ಕೆ memo.
Which one?
No, fresh matter, Your Honor, not listed today.
Oh, you want to listing?
Memo for posting, Your Honor.
After vacation.
No, Your Honor, on 9th or 11th, I will comply all of his objections.
22nd.
Any other mention through VC, sir?
Opponent 1 and
Lords, one is that company matter which your lordships heard the other day, Lords, where we suggested even a receiver could be appointed and arbitration, my lords, your lordship suggested if both of us we are agreeable, we had named,
Awaiting the name.
my lords, we had named the Honorable Justice Gurajan, but we leave it to my lords at the, we would prefer at the arbitration center, my lords. That's more, anyone who attends the center, if
we very much agree on that, but suppose if his lordship is free, they are not is busy, that the alternative name would be Justice A.V. Chandrasekhar, subject to, suppose for whatever reason, if his lordship, Justice A.V. Chandrasekhar, subject to availability of his lordship.
Chandrasekhar or Justice Kumar, who, my lords, we leave it to my lords. I have.
No, you give a joint memo, then there is no point.
No, Chandrasekhar, his lordship Justice Chandrasekhar would do it. Lordship Justice Chandrasekhar.
Or Justice Jagannathan.
Why don't you give a mail? So
Yes, certainly.
Justice Jagannath.
Give
Lords, we'll file a memo.
And submit.
Give in the course of the day, we'll tomorrow discuss.
Please, my lord. That so far as that. Receiver, my lords, your lordships can take a call, my lords. Usually IRPs are there, but I don't know whether the resolution professionals will agree to.
Any charter?
Yes, I'll leave it to my lords, any retired judge or retired bureaucrat whom your lordship suggests. We have no issues on that. We'll leave it to the best. I don't want to name anyone.
That a memo is served on me.
That's we have prepared a memo for instructions to the receiver how it should be handled. That we leave it, my lords. The modalities, and our only concern is, my lords, both of us have fixed the venues. We have given the dates. Beyond that, my lords, till the issue, both of us will not conduct any business. Beyond these dates, where we have fixed the venues, they have also booked. We have also booked the business. So after these dates, my lords, that is the wedding venues which have already been booked. That my lords, after that, let it not.
I'll make this submission. Now, each one of the instructions, my lord, we have absolutely no objection. So far, he has also made the bookings, contrary to the partnership, and it appears we have also made the bookings. The intention is, kindly see, the contribution from my friend is about 4 acres and that. We have built about 52,000 square feet of built-up area, which covers several. I'll submit the entire theme of the marriage and all that. Now, the memo proceeds on the basis there is already a dissolution. There is no dissolution in the IFLA. I can still demonstrate before your lordship. The receiver who is appointed will be appointed by this court. Let him continue to make the bookings. The whole idea is to stop the business so that the partnership will be collapsed instead of dissolution. They are asking for dissolution. The whole idea is to see that it collapses. It cannot be done because let the receiver continue with the activity. Let him make the bookings. We will cooperate. He will also cooperate. The money, we have invested about 5.
With the arbitrator once he starts the proceedings.
But show must go on. Let him also earn. We will also earn.
Not necessary.
We should have faith in the receiver.
We have lost trust. My lords, I am only saying this.
Trust in the receiver.
Dates are there. The dates also we have given. Yes. Through the receiver.
Yes, certainly.
Okay. Very well.
Certainly.
And any relief will go before the arbitrator, my lords. That. Yes. Please. Please.
Certainly.
The arbitration, my lords.
And all the 3 of us will cooperate with the receiver in running the show. That's what they have said. That is what they have.
Any further orders will
they
be
have
before
made
the
a very
arbitrator. Any further orders we require before the under the arbitration. 17. 17. Please. Well,
but
only the name of the receiver will leave it to my lords, because if I name somebody, please, my lords, any name. My lords, I'll give the memo of instructions to the receiver and
B. Party shall assist the receiver appointed by this court in smooth running of the event. Certainly, absolutely. Only thing, he should not stop. Let him also earn. We will also earn.
Please. May I just place this memo, my lords, with the dates we have given. Please.
But further bookings will be done by the receiver and we will cooperate. That's all. Receiver.
Receiver, I have.
We will leave it to your lordship. There is a case officer. Case officer or Tahsildar.
Please,
this will cover the other matter which is not listed. 199.
At page 5 and 6 sets out the dates when both of us have booked. Instructions, my lords, we have set out at page 2. Para 3, my lords, the
Next. Instructions, correct. Oh, we will disclose Allah. Parties shall disclose all the bookings. Parties shall disclose all the bookings. Sahib, ಅವ್ರು ಸಾಹೇಬ್ ಹೇಳೋದು ಕೇಳೋದೇ ಇಲ್ಲ.
The name of the arbitrator and 2-3 names of receivers subject to your lordships. That minutes.
ಶುಭಸ್ಯಂ ಶೀಘ್ರಂ ಸುಮಿರಿ. Oblige. The connected number will give to them.
My lords. My lords.
Other two connected matters.
My lords, they are all arising out of the same orders. What we have challenged, and it's the same, my lords.
Get it listed.
It can be just connected, my lords. There is no separate arguments on those.
So इसके साथ the other two cognate company appeals, name number shall be listed by the office along with the present cases.
Seal number 3, Mr. G.M. Nataraj.
There is no, Miller, the order was made on 7/3, it was Friday. Saturday, Sunday was a holiday. On 11th, Tuesday, I have served to the government 6 sets. And 12th for the rest of the advocates are taken. Only one day there was delay, Monday, because it was 700 pages Xerox had to be done and 16 respondents. Only one day delay. Otherwise, I had taken my. I had taken service notice. I have served. There is no delay on my part. Yes, awaited. I'm not disputing. For office, there was a slight delay, my lord.
Notice is awaited. So we'll
Awaited.
wait. This notice is awaited to be posted on after 11th of June.
Oblige.
Contempt matters. Seal number 4, Mr. Kumar KG.
This contempt.
Notice.
There's a delay of 463 days.
Because the petitioner, my lords, died. He will now.
Although the application for LR may be allowed, coming on record may be allowed, still it is attracted by section 20.
What is IU 1 of 25?
Lords, for prosecute, my lords. The
Along with this contempt petition, also filed is the application. On 2/4/25, puts of the directions under the contempt, brought under the contempt of court of contempt are dated, are in the order of Lorna Single Judge dated 19th October 22, passed while disposing of the writ petition number 20700 of 2022. Then there are two. As seen above, the directions were passed on 19th October 2022. Full stop. This full stop section 20 of the Contempt of Court Act reads as under, and Court section 20. Full stop. It is provided it is the statutorily provided that the contempt proceedings shall be barred after expiry of period of 1 year. As the contempt petition was filed.
Seal number 5.
Yes, what is it about?
So the adjacent landowner, there is no relinquishment.
There is no. So what is your case? What is your case?
Senior.
What is your case?
Senior okay for
We are not granting time in any NAPIL henceforth, which are old. We are not granting time.
Please pass over, my lord. Pass over.
Also,
My lords, I am appearing through VC, my lords.
Yes.
My lords, this is a
Yes.
public interest litigation wherein, my lords, the lands which have been relinquished in favor of the government, my lords, has been unauthorizedly tried to be occupied by the parties. Permitted me to bring it on record, my lords.
no, you proceed with this matter. We don't have the memory. At least I don't have any memory.
Yes, my lords. My lords, so, I draw the attention of this honorable court to page number 36, my lords, which happens to be the layout plan, which comes to be sanctioned
Yes.
for development of the property, my lords, bearing survey numbers 21/1 to 8 for 4, and also schedule 2 property, my lords, that is 21/2 and 21/9, my lords, in which the layout has been formulated. We are, my lords, with respect to serious site number 8 and 7 of the said layout, my lords. Now, after having relinquished the said property to an extent of about 30 feet for the purpose of road, my lords, now that they have also encroached the roads, and they have also been trying to erect a commercial property on the said roads, as well as the road which is belonging to the governmental portion of the property. Now, questioning the same, my lords, yesterday also a writ petition was filed in which they had, my lords, taken plan sanction for an extent of property which is already been demarcated for the purpose of developing of district highway. Now, this is a property in which, my lords, after having obtained a layout plan, they have been encroaching upon the road and they want to develop the property. My lords, I have provided the photographs, my lords, which my colleague would be handing over to this honorable court, which shows the present position of the property, my lords. My lords, which my colleague would be handing over to this honorable court, which shows the present position of the property, my lords. Representations came to be made by the parties, my lords, which is at page number 40, to the Chief Officer, Bhagyanagar Town Panchayat, whereas no action has been taken as against the same.
You are saying that certain lands are relinquished.
They have been relinquished in favor of the government, which is a road, my lords, 30 feet.
Some relinquishment for public use.
Yes, my lords. It is a road. For formation of the road, it has been relinquished.
Relinquishment, not extent of
No,
road.
specific relinquishment, I do not have that records, my lords, whereas for a grant of a layout approval, my lords, relinquishment is a must, which they would have submitted to the department. Otherwise, they wouldn't get a plan sanction. And then, my lords, your lordships would also see a kata has been produced by me.
Petitioners appears to be adjacent landowners. Proceeding the right of access through this layout.
Who are you?
My lords, we are the petitioner. We are the localite of that area, my lords.
We know that you are petitioner, but who are you?
My lords, I am the localite of that area. I do not have any personal interest in this case, my lords, but I am a resident of Koppal. And my lords, this road as well as the property which has been left out for widening the district highway, my lords, both are required for movement between Koppal and Kinnal. Therefore, my lords, I am alternate in pressing upon that request, for which I have made representations to the department. None of them have been considered. My only contention is this, my lords. Even as per the kata which has been issued in favor of the private owners, my lords, it has been categorically mentioned that it is a 30-feet road, which is to the eastern portion of their property, which your lordship should get at page number 47, my lords. The second column, my lords, second row. It says that Bowden on west by 30-feet road. This road has now been occupied by them. The public property has been encroached upon, my lords. By their act. And the photographs, my lords, of the recent position of the property also have sent it along with my colleague, my lords, for the perusal of this court. Let's, all that I have sought in this case is that to assess the property and remove.
Or learned will ask you to go there, they will examine. We are not entertaining. Or learned advocate, Mr. So, who appeared through video conferencing, assisted by learned advocate, so, present in the court for the petitioner and learned additional government advocate, Srimati Nilo Faraswar, who appeared to assist the court upon service of copy of the petition in advance. The petitioners who claim to be the residents of Kopal, further projecting themselves to be those involved in the social welfare activity and public spirited person and asserting them to be public spirited person. They filed this petition, styling it as public interest petition. Full stop. The issue sought to be raised is about the subject land out of which, as per the case of the petitioner, land out of which the portions were relinquished for public purpose within the course of the development of the property. The lands involved is small Roman 1. Yeah, bracket, page 9. And 2, Roman small 2. Bracket. It is the case paragraph that both the above properties were developed as residential layouts by their respective owners after obtaining necessary approvals from the competent authorities. As per the case, the layout plans indicated that special portions of the property were earmarked for road development on the western and eastern boundaries for the purpose of providing connectivity and access to the public. It was stated that during the process of granting approval, certain portions of land were demarcated as public roads in the scheduled property and were relinquished in favor of the respondent department. It is the case that despite this relinquishment, certain antisocial elements have unlawfully encroached upon the areas and unauthorized structures are constructed. Very good. It is the further case of the petitioner that despite several representations were made to the local authorities, urging them to take immediate steps to remove the encroachment, nothing has happened thereafter, and that the authorities have failed, respondent authorities have failed to take any action. In this light, the prayer is made to direct the respondent authorities to land earmark for public road development. Next prayer is made to direct the respondents to take measures to prevent the future encroachments on the property and further that public lands in their jurisdiction, including the establishing of monitoring mechanisms, etc. Deserves to be prevented, and it may be ensured that the encroachment does not take place. The whole plank of the grievance is that some part of the property was relinquished in favor of the respondent department to be used as common road. However, in this regard, except bare evidence that there is a relinquishment, no cogent material is forthcoming on the record.
Layout sketch as well as Kata is there, my lords.
When learned advocate was queried about this, he referred to the map at annexer C37 at annexer B, page 36, full stop. It is difficult to find any substantiation from the Xerox copy of this document without any authentic document so suggesting. Establishment thereof, the court is not inclined to entertain the petition. The petition is dismissed. However, it is observed that if any illegality is committed in the matter of occupying the land and encroaching the same, the authorities shall look into in accordance with law. Petition is not entertained subject to above limited observations. What is this?
Seal number 6.
Makers, my lords.
At custody.
No, this is relating to matter relating to right implementation of Right to Education Act, my lords, where out of school children have to be brought back. So there are certain reports which we have filed as an amicus. I have filed, my lords. The last report being, my lords, on 12/12/2024.
Beggars, children, no.
My lords.
Children of beggars, no.
My lords, children, no, children, my lords, of laborers, everyone who are out, how to bring them, and the infrastructure in government schools, my lord, regarding drinking water and toilets. So far as BBMP is concerned, my lords, we have given a report where, my lords, this honorable court on the last occasion, my lords, had directed that any survey to be done by the state for all the schools should be in the presence of a secretary, or the report should be seen by the Legal Services Authority, because their reports, my lords, they were just submitting everything is all right. That, my lord, the government had submitted. We have given reports where we have pointed out certain deficiencies in our report. On Friday, the government has given me another compilation saying that deficiencies what I have pointed out, they have rectified. I'll have to go through government's report. So far as BBMP is concerned, they have in their report said we contacted the Legal Services Authority, but they refused to come for the survey. They say almost everything, all the schools are in order, which, my lords, I find drinking water facility is fine. In fact, my report is of 12th of December. BBMP has not got back on that, where we have said it can't be.
Yes, who appears for BBMP?
I appear for BBMP, my lords. My lords will file a reply on it, my lords.
No. Reply.
Our report. In fact, BBMP.
How many schools are run by BBMP?
They say it's 49 schools.
49.
49 schools is what BBMP says. Primary is 16. High school are 33. Totally 49. Their report was filed on 13/11. We have filed it on 12/12, in which they say Legal Services Authority was asked to participate, which may not be correct.
Across Bangalore. At a time, we'll let the law students go and inspect and back very well. Attendance students will get, law interns will get. We'll make a team of students and we'll ensure. And even if required during vacation, even the judicial officers. One day, any day fixed. One day is this to last.
Which applications will you file?
Okay. Okay. Have some knowledge. And they
That door-to-door search.
it's active.
It has been done, we have given a report, they'll have to do one more exercise.
The same petition, they have taken different backgrounds. Winter was there was no need of water the next week.
In fact, the BBMP's report is dated 13/11/24. Because toilet and drinking water melodies is a basic thing. 2 toilets per school, one for girls and one for boys. The lordships have the BBMP report. Please come to para 4 in that.
Schools are supposed to be the parties.
Pardon me, my lords? My lords?
Schools are supposed to be the parties or not?
No.
No.
Now, my lords, these are all BBMP schools. Now there are 2 things, my lords. Except BBMP limits, all the other schools, we are talking only about government schools, my lords. They are maintained by the government. We are giving reports, and at least the government, my lords, they are interacting. Every time I file a report, they give us the status of wherever we have found out deficiencies and pointed out to them.
So what does the BBMP report say?
BBMP report says everything is fine in their schools. With 4. It's with photographs, it's a big company. In that, if your lordship sees para 4, because the idea was if the legal services authority, that's what has been done for the remaining government schools. This honorable court directed that somebody from the legal services authority should be present for the survey to know the truth. But at para 4, they say they requested legal services authority and legal services authority refused. ಇದರಲ್ಲೂ 10 ಗರ್ಲ್ಸ್ ಬಾಯ್ಸ್ ಎಲ್ಲ ಕೊಡ್ತಾರ. And if I can show your lordship sees, it's a very casual report. If your lordship sees 11 of is Bangalore, page 11. Total number of toilets available column, your lordship should get 2. And toilets for boys dash, toilet for girls dash, number of toilets functioning 2. So we don't, this water also sump overhead tank, sump water supplied for all students. We don't know whether it's for boys, girls, and the act mandates and the code.
Over several months.
What are the 20? I also don't know whether the serious of what's one or two issues. Which is that memo I want to read? Date.
Last, he asked me to provide synopsis. I'll give. I had mailed it.
But because their schools do not seem to be in a good apart from this, the other issues, my lords, are regarding the door-to-door survey, which the government has to answer, and the meetings, my lords, high-level meeting chaired by the Chief Secretary. Quarterly meetings have to be conducted. Those, my lords, the government may have to look into, and because that's been raised even by the party in person.
Your Honor, I've raised all the issues in my synopsis. If I may summarize those issues, and if you take it on record and give a direction to the respondents, it would be useful. There are so many other issues other than the BBMP survey.
The present is in the newspaper Hindu relating to lack of infrastructure. Relating to lack of implementation of the provisions
of the Right
to Education Act. Inter-alia, lack of, including lack of infrastructure.
Including.
Of sufficient toilets.
And drinking water.
Drinking water facilities for the students studying in the government schools.
Government schools.
In the government schools. The petition was filed thereafter by the registrar judicial of this court, which belongs to the year 2013. Time to time, paragraph. The readings and reports are filed by the respondents upon various orders passed by the court. They figure on record. They all figure on record. Full stop. All learned amicus curiae and senior advocate Mr. Manindra. From learned additional government advocate Srimati Neelofar Akbar. Subject matter from the cause sought to be espoused, as well as the developments which were brought on record. On at different times during the pendency of the petition. Full stop. It was pointed out that about 49 schools wherever in the city of Bengaluru run by the Virat Bengaluru Mahanagarpalika, now integrated BBMP, not for the first time. BBMP. क्या लिखा? Are run by the full stop. The BBMP has filed status report. In respect of infrastructure available at these schools. Full stop. The report was filed pursuant to order dated 9/10/23 passed by this court, whereby the BBMP was directed to conduct a survey of the schools and place a report. Full stop. The report figures on the record. Wherever. Learned, according to learned amicus curiae, the report is a face-saving exercise, and it appears that the true facts have not been revealed. Full stop. Since the report was undertaken by BBMP about the state of affairs regarding infrastructure of toilets, drinking water facilities, cleanliness, and availability of basic amenities to the students who are imparted education in these 49 schools. Full stop. In that view, the Secretary, High Court Legal Aid Services Committee, for State Legal. The Secretary, the State Legal Service Committee, is directed as under comma. The Secretary, Karnataka State Legal Services Committee shall immediately proceed to constitute a team comprising of 3 members, whom shall be included a judicial officer of the rank chosen by the Secretary, and 2 law students.
Yes, interns.
To act as volunteers, legal volunteers, studying in any of the law schools,
Law college.
law colleges in the city. 2, the number of teams, number of teams with such constitution. The teams with such constitution shall be formed in the numbers as may be required to visit 49 without notice to
BBMP. But they'll need assistance from BBMP. They will need, because their
full stop.
Their addresses or something if they want.
Full stop. The The secretary,
Surprise inspection, your lordships. They can collect the details of the schools and do surprise inspection or something. Because the schools are here.
constituting the committees as above, simultaneously shall solicit the details of the schools to be visited by the committee from the BBMP. The BBMP is directed to next extend cooperation in this regard. Full stop. In the visit to be conducted by the teams to such schools, comma, the teams shall examine and take assessment of the infrastructural facilities in relation to the toilets, adequacy and cleanliness thereof, comma, the drinking water facilities, comma, the general cleanliness in the premises of the school and other basic amenities needed for the healthy climate in the school to be made available to the students. Full stop. The entire exercise without now continue regular. Entire exercise will be completed within 1 month.
Yes.
1 month from today. Full stop. The elaborate report shall be prepared with reference to each of the 49 schools and shall be placed before the court, signed by all the members of the committee, as well as signed by the
Simultaneous and
They can engage the services of judicial. 26th is the last week and
Your Honor,
yes, still not complete.
the issue is not only about the infrastructure, there are so many other issues. The main issue is about the children who are dropping out.
We are still not finished. That part is still not finished.
So we also involve the High Court Legal Services.
Please.
In coordination with.
With yourself.
in this month, this was it is 26th April. Just wait out the direction.
Will properly vet the direction.
Please, minutes. That time.
Because one of the officers is retiring on 30th
Let's.
April, so report shall be submitted. Detailed report shall be submitted on the above, giving the information about the above facilities in respect of the school, each of the 49 schools, and shall be placed on record of the present proceedings. This may be listed next on after vacation.
After vacation, your lordship can
The,
have.
the petition may be listed on 12th of June.
That's,
That's-
that
Oh, yes,
simultaneously.
they are pending. IA number 21, 1 of 21 and 1 of 22. 21 has been filed before this court by the students. Their writ petition has been dismissed by the sample court. So therefore, they were not placed any material before this court. Therefore, their application.
Your lordships have said simultaneously / contemporaneously. In case they can't do on the same day, my lords, the inspection for 49 schools, they can do it in a day or two. Like that's all.
Contemporary, not
Please.
simultaneous. Contemporary. Instead of what simultaneously, contemporaneously.
Your Honor, could you kindly direct the respondent government to look at my submission, the synopsis that I've given, and may it be taken on record and ask them to give a response?
Consider this is not disposed of.
Sorry, sir.
Proceedings are not disposed of. We'll consider one by one all.
These issues have been pending since more than a year.
Correct.
That is they have not done the survey of the children to create the database that is supposed to be done every year. And already 1 year is over and the survey report of last year is still not available from the Urban Development Department and the RDPR department.
This exercise
And
undertaken.
unless they have a statistic of how many children are out of school.
That will take up next time, one by one, one by one.
Your Honor, these issues I have been raising these issues since several months, since last January.
But it has to be done one by one, madam, not at a time. We'll address all issues one by one.
Your Honor, as per the decisions of this honorable court, uh, the rules were changed to have a preventive protocol to ensure that all children are in school within a time frame. Now, they are giving reports, even in the newspapers, that thousands of children are still out of school, and they are not implementing the rules that were, created by this honorable court. And so we want them to ensure that the rules are implemented properly. And Your Honor, because of our effort,
You file your reply.
we should replicate what this court
Part in person is taken on record.
Cell number 7. Ramesh Chandra.
I seek short accommodation in this matter. We have implemented the respondents, ma'am. Their address are not they are going to Jainagar shops allotment, my lord. They are held. They have a responsibility.
Give the facts. Give the facts. What are the facts?
It is a shop allotment, my lord. BBM committee for the shop.
You must have drafted the petition.
This, I have not gone through the papers. In this, I have not gone through papers. Senior argument.
An interim order is operating?
No, my lord.
No. Then we dismiss it.
No, pass over, my senior.
No pass over. You proceed. Learned advocate, Mr. So-and-so appears for the petitioner is unable to make submissions as appears to be not prepared on facts. He requests the court to grant time on the ground that some inconvenience. Full stop. There appears to be no urgency in the matter. Stand over to 27th June. Yes.
The communication which we have challenged has been withdrawn by the authority, Your Lordship. So I filed a memo for withdrawal of the petition itself, Your Lordship. I filed a memo.
Mr. So-and-so invites attention to the court. Where is that memo dated?
Memo dated 3/4/2025, Your Lordship.
3/4.
File ಮಾಡಿದ್ದೀರಾ?
File ಮಾಡಿದ್ದೀವಿ.
No, it is not on record of the court.
May I pass on this one, Your Worship?
But it is not on record of the court.
May I pass on this one, Your Worship?
Memo dated. Memo dated. Not this. It's filed on 3rd. Memo dated. Learned advocate Mr. Swanson states for 25, withdrawal of the petition. In view of the respondent number 7 has, in view that the respondent 7 has withdrawn the communication dated 24th, 2005. In the, get it on record. Yes, by tomorrow. But
This writ appeal matters, seal number 9, Mr. Karthik NBS.
delay of 146 days. Notice 27th of June.
My lords, there is another writ appeal. There's another writ appeal, my lords. It may be connected. I'll share the number, my lords.
Writ appeal number so and so shall be listed along with this appeal on this next day. Full stop. The appellant in that appeal shall remove the office objections, if any, before the next.
Please.
Seal number 10.
Notice.
Please, my lord. Challenging the very same judgment, this matter may tagged along with that matter.
6.
Seal number 11. It's a state appeal.
Notice returnable on 30th June.
Please, my lords. The delay, my lord.
Again, 806 days.
Yes.
Notice. Returnable on
I'm great.
13th June.
The 13 is adjourned. Seal number 14, Mr. Rajshekar S.
And FA for appellant. But the issue before the learned single judge was, my lords, relating to an official memorandum issued by the government. But say the learned single judge, my lords, very strangely, my lords, holds that, my lords, this issue is relating to, my lords, property dispute. And disputed question of, my lords, facts cannot be looked into in 226. That is the view taken. May I request my lords to kindly turn to page 23, my lords.
Civil suit is pending.
My lords, civil suit, no doubt, my lords, appeal is pending. The status quo in so far as my position is concerned. Now kindly see the annexure, my lords, my lords, for a moment, which says, my lords, they would like to, my lords, fence the property belonging to me, my lords. Kindly turn to annexure my lords, page 226. Type translated copies at page 229. I can understand, my lords, when the repeatedly the courts have held that, my lords, we are in possession and enjoyment of the property. Question of, my lords, fencing our property does not arise for consideration. That too, more particularly when, my lords, the matters are pending for adjudication. Admittedly, my lords, 136 proceedings initiated before the deputy commissioner is pending adjudication.
What is the prayer in the petition?
Prayer may kindly be seen, my lords, page 44 minutes to quash the order passed by the respondent number 2 by the official memorandum dated so and so, pending disposal of the writ petition. By virtue of official memorandum, my lords, the authorities have, my lords, reserved 26 lakh rupees so as to fence my property. There is no dispute. 6 had initiated proceed.
Some order was passed to construct compound.
Yes, please, my lords, to my property. My lords, this is another way of, my lords, taking physical possession of my property. Now, very
Go to civil court. File
lords, civil court, my lords, if they are aggrieved, my lords, they should go to the civil court. I am in constructive possession of the property.
You are aggrieved because
My lords,
compound-
they have initiated proceedings, my lords, to evict me from the property. That ended in, my lords,
property 79 Neil Sandra village belonging to Sri Dharmaswamy.
my lords, that is what they say.
Is whose property?
That property belongs to us, is our claim, my lords. From 1940s, we have the sale deed.
They are
Conflicting claims between the temple and the.
Once.
We have told.
They are constructing the compound wall.
It belongs to the Muzrai department, my lord.
The claim is made, I'm sorry, my
Lordship.
Civil dispute is pending between you and?
No, Lordship, there is
amongst
no
our
civil-
family members, my lords. And there is a status quo order.
So why you are interfering?
My lords, what happened is there are conflicting claims, my lords. By virtue of Inam Abolition Act, temple was granted the occupancy right. Then because of the earlier occupancy rights, land, there's a large extent of land belonging to the Muzrai department. To protect the land,
And the subject matter of the civil suit is same property.
Lordship, it is not same, Lordship. It is not same. Lordship, insofar as civil suits are concerned, Lordship, they filed civil suit for adverse possession that is rejected. And against that, my Lordship, they filed MFA, the RFA before this honorable court. The same has been also rejected. Now, my Lordship, by way of, my Lordship, this is only deputing the officials to the spot, my Lordship, to protect. During the construction of the compound wall. Now compound wall is constructed and insofar as vacant portion of the land is concerned, my Lordship. My Lordship, I have photographs. My Lordship, kindly. My Lordship, I am for the 6th respondent, the temple, my Lordship. My Lordship, this.
Who are they then?
My Lordship,
Are
they are
private
claiming
claimants.
unauthorized occupants, my Lordship. We, during my Lordship conducting the, my Lordship, inquiry, there are 216 unauthorized occupants found, my Lordship.
I have produced the
In
sale deeds
civil
of
court.
1940s.
Please, Lordship.
My lords, I have produced the sale deeds of 1940s. Now, my lords, insofar as the contention that, my lords, may I request my lords to kindly turn to page 176 for a moment. The proceedings initiated under the provisions of, my lords, Public Premises Eviction Act came to be set aside by the district court. That ended, that order came to be, my lords, attained finality.
Lordship, kindly come to page number 430, my Lordship. That is the earlier order passed in RFA, my Lordship. This honorable court passed the order.
In that, my lords, there is a
430.
finding as well.
Lordship, kindly come to 32, my Lordship. Para 32, page number 453, my Lordship. All, Lordship, may the shoot land of more than 30 years not established by the plaintiff. As such, he is unable to prove the 50 years. Cannot be. Lordship, now
Hard learned senior advocate, Mr. Assisted by learned advocate for the appellant's original petitions. Learned additional government advocate Raghavendra. Raghavendra?
Ballots. Naveen Chandrasekhar Kumar.
Sorry. Mr. Chandrasekhar, Naveen Chandrasekhar for respond 1 state and respond 2, 3 and 4. 2, 3, 4, 5 and 6 all and 2 to 7. The authorities of the state.
6, my learned friend appears.
The dispute centers around paragraph. To the land property bearing serial number 79. In Neelasandra village. It appears that on the said land, Sri Dharmaraya Swami temple.
please, Lordship, Dharmaraya Swami.
In Thigala,
May interfere.
Bengaluru city is situated.
My lords, there is no temple, my lords. They claim that, my lords, this property belongs to them, to the temple, but temple is not situated.
It is claimed to be belonging to Sri Dharmaraya Swami temple in Thigalarpet. On the other hand, the Deputy Commissioner paragraph, Bengaluru District, Bengaluru, issued official memorandum dated November 12, 2020, which was regarding the protection of the said land. It is stated in the said official memorandum that disputed by the petitioner in respect to part of the land. The official memorandum mentioned release towards cost of the construction of the wall. The officers
12/11/2020, my lords.
12/11/2020, which was challenged by contending that part of the property. Paragraph while in the civil court, right, claimed for the part of the property. A civil suit are not in dispute. As rightly observed by learned single judge, the also only deals with the aspect of protection of the land, survey number 79, situated in Neelasandra village, in respect of which the rival claims are advanced about the ownership. Full stop. The reasoning adopted by 11 single judge while dismissing the petition could be said to be eminently proper and legal when it is stated that when parties are asserting their civil rights of ownership over the property from such question relating to title cannot be, such question cannot be agitated in the writ petition. Full stop. It is also stated that it is also rightly observed that the issue involves disputed questions of fact. Paragraph. It is right principle that the titular questions cannot be agitated nor can be gone into in the proceedings of writ petition under Article 226 of the Constitution by the High Court. Full stop. When the challenge to the memorandum, official memorandum dated 12/2020 had background their claims by the appropriate formats. It is always open for the parties. 20th June. In delay application. We are keeping this on 16th. It's already argued.
We have argued the case.
Sixteenth. Since it is already argued.
Commercial appeals, seal number 17.
I am for petition. My lord, suit is one for injunction and money recovery suit filed by the respondent plaintiff against me, my lord. Without having the document, without any contract, without any agreement, my lord, they filed the case, my lord. The Honorable Trial Court, not following the section 12A of the Commercial Court Act, application filed by the respondent plaintiff has accepted and admitted the case, my lord. This is a totally money recovery suit they filed, my lord, for the 27 lakhs, my
matter, my lord, otherwise it should not. Okay, I mean, seeking a declaration that section 40 of the Biological Diversity Act is contrary to Article 14. Yes, my lord, pleadings are complete. We have filed the reply.
Next week, any date, my lord. Next week, any date, please, my lord.
Next week.
Next week. My lord.
This petition itself.
28.
Please, my lord.
28. What will that be? 2 days before. Whatever order. I've seen this. After that. Nothing will happen. 2 days before. 1 day before vacation. In vacation days. Don't worry. It's not what it said. Since too long, yeah. Sinner, sorry. Thanks.
And the file is also destroyed, they say.
My lords, requesting for short accommodation, my lords.
What is it?
The issue is sub judice before the Honorable Apex.
It's pending since 16. 16?
19.
16 matter, what is this?
The issue is also before the apex court, my lords.
What apex?
With regard to the validity of Rule 32, my lords, it is
Notice. If you make such
Sorry,
statement.
Lord. I'm sorry, Lord.
Where is the affidavit?
Lord.
Notice.
Lord.
If you make such
Sorry,
statement.
Lord. I'm sorry, Lord.
Where is the affidavit?
Lord,
Where is the affidavits? Where is the affidavits? Where is the compliance of this order? Don't make irrelevant submissions. Not uploaded, not uploaded. You are there in the open court. It was signed yesterday. It is available. You know the order. You know the contents of the order. You know the directions. You know your duty. And you are teaching us?
I'm sorry, Lord, and not on that, please, Lord.
You are teaching us?
Lord, I request, Lord.
You know the order, it was dictated in open court. We dismiss on this ground only. When you are going to file affidavit as directed?
Lord, 16th. May I
No,
request?
file tomorrow.
Lord,
Where are these? Where are your clients? Where they are located? Residing? In Bengaluru or outside?
Lord, I'll
You
take
don't
in-
know, then we dismiss it. Learned counsel is not ready to proceed with the matter, nor is.
Lord, 16th, Lord, I requesting 16th,
No, sir,
please,
no.
Lord.
No is no.
Lord, at least Monday, Lord.
When
may I
you are
request on
misleading
Monday,
the court,
please.
misguiding the court, browbeating the court by such statements, no.
Lord, with
You are there in the court, openly dictated. It is a long drawn proceedings, long drawn hearing, thereafter this order passed. If you want to say that we are not able to file affidavit, different thing. Don't say that order is not known to you.
Lord, may I request on Monday, please.
No